Well, good evening, everyone, and welcome to the Brian Crombie Radio Hour on Saga 960 AM. I'm on every Monday through Friday at 6 o'clock on 960 AM, or you can stream me online at www.960am.ca, or you can get all my podcasts and videocasts after the fact on my website, briancrombie.com. So I think probably the number one issue right now after COVID-19 is because of COVID-19, do you send your kids to school? And so I wanted to check in with Michelle Walton. Michelle Walton works for a company called Phoenix. What is it? Phoenix Family Dispute Resolution. And she calls herself a family law arbitrator and mediator. And what she does is she is sort of a parental coordinator. One of the big issues between parents right now is if one parent wants the kid to go to school and another parent doesn't want the kid to school, what do you do? And so, Michelle, thank you for joining us tonight. How are you?
Of course, I'm well, thank you. Thank you for having me. It is a huge issue right now for parents who wants to send their child to school because they have to go to work and they have no other way to work other than for their child to be in school. And then sometimes on the other side is a parent who's just really nervous about sending the kids back to school and what does that mean? And certainly with the new Quebec news that we received this week, I think it was Monday or Tuesday, they announced that 80 kids are now in quarantine from 2 schools in Quebec and Montreal, with 2 confirmed cases in Quebec and 1 confirmed case in Montreal. And so the situation is super fluid and it's changing really quickly, and courts and judges and arbitrators are being forced into these decisions as to what do we decide to do with somebody else's child. It's a really difficult position to be in. And recently, Justice Andrea Himmel, who was just appointed in Newmarket, came down with a decision that said the child will go back to school. And last week, there was a justice in Toronto that said the child won't go back to school. So it's really a roll of the dice, deciding on whether you... on
which justice you get.
On which justice you get. And I think it really comes down to, because I've had 4 decisions before me where I've had to make the call on whether or not the child should go back to school. And it really comes back to the fine details and the context of the family dynamic. How many children are in the home? Are the children going to see another home that has stepchildren in it? Is there anybody in the home that's immunocompromised? Do they have comorbid issues? There's so many details that you have to kind of flesh out all the details to try and come up with a decision. But ultimately, the only people that know what to do best, I would suggest, are the parents of the child. It's a huge...
But what if the 2 parents disagree?
2 parents disagree.
Which never happens, right? Never happens.
Never happens. This really just is another battleground for parents to argue in high conflict situations, for sure. But I think I think it's valid that some parents are really struggling with, do I send my child back to school? And if I do, what happens if that child gets COVID, or if they're in, maybe they don't know about a comorbid issue in their child, and their child has something undiagnosed, and they send their child back to school and the kid gets COVID, and then you have another problem on your hands. And so I think parents are really scared, and we're charting unnavigated territory, and with a situation that's so fluid and information coming down from the government every day about different plans that are happening, what's going to happen with each different school board. I think it was the Toronto school board, their reopening plan was rejected initially, and they had to go back and rejig their plan so that it would be passed so that they could open. So nobody really, I feel like we're gambling with our kids a little bit.
Well, you are to a certain extent, but your situation is even worse, because you're supposed to decide between 2 parents that are warring over the issue. So let's take a step back. What is a parental coordinator, and how could you possibly make this decision?
So parental coordinator is somebody that steps in that's a neutral with a 2-home family with separated parents. And a lot of times in high conflict cases, to keep families out of court, what we'll do is we'll use a parenting coordinator. We'll appoint a parenting coordinator into a mediation arbitration process, meaning that the parents no longer have the right to go to court for any issue that's within the parenting coordinator's jurisdiction. So going back to school would be an issue that would be within the parenting coordinator's jurisdiction. And so instead of going to court, they would come to an arbitrator like me. I would initially try and mediate the issue and parse it out and and do some education on both sides and see if we can come up with an agreement. And if we can't, then it moves into somewhat of a private court process that's still formal and still based on evidence. And each party presents their side with counsel or without counsel. And then ultimately I would make a decision based on the evidence that's in front of me.
We're chatting tonight with Michelle Walton, who is a parental coordinator, talking about primarily the issues in regards to sending kids back to school. We're going to take a break for a message and just be right back. Stay with us. Welcome back to the Brian Crombie Radio Hour. We're talking about kids and COVID-19 and going back to school with parental coordinator Michelle Walton. Michelle, you say you get to arbitrate. What kind of background do you have that makes you the person who gets to arbitrate between two parents that are warring over their kids going back to school? Like, are you a lawyer? Are you a judge? What gives you that right?
No, so I have my master's in social work from the University of Ottawa, and I have my degree in psychology, and then I did additional training in mediation, arbitration, and family law. So for years I was in the courts doing court-based family mediation, and then I branched out and started my own company, Phoenix Family Dispute Resolution. There's a great need out there for parenting coordinators. It's something that, from my perspective, I can really give back. I'm not really interested in parents fighting over $30 for back to school supplies or the house or whatever it is that they're fighting over financially. But what really speaks to me is creating some continuity for kids and creating immediate decisions for them. So even though their parents have split up, their life still kind of gets to move along in somewhat of a stable manner. And sometimes it works and sometimes it doesn't. I've certainly had a ton of success with parents that use parenting coordination appropriately and are able to take kind of a step back and reflect on their behaviors and understand how it's impacting their kids. And sometimes it doesn't work, and the best thing is for the families to go back to court. But certainly parenting coordination, I love what I do, and I feel like I can make a real impact for a lot of kids out there that are just kind of stuck in these tumultuous waters of divorce and separation.
It seems like it makes a lot more sense than running back to court all the time.
It really does. And it can be a really expensive process in that it costs a lot of money to fight, but it's certainly less expensive than going back and forth to court because the parents share one bill, as opposed to each of them sending lawyers letters back and forth about Johnny attending soccer instead of hockey, or dance instead of gymnastics, or whatever the issue is, or can I go to a wedding but it's on the other parent's weekend, and how do we kind of navigate that? And a lot of times there's so much hurt and there's so much water under the bridge, so to speak, that every new request from another parent kind of opens up that wound. And what the parenting coordinator is able to do is give those wounds a chance to heal, educate the parents, and work with the parents on communication issues and how to effectively speak to a partner when you're in a separation. And the hope is that it kind of gets rid of some of that conflict and helps the kids live in a more calm, stable environment.
Do you spend time with the kids to understand what the kids want to do?
I try my best not to meet with the kids. I have a couple files where I have met with the children because the children are of an age and the parents have told them that a parenting coordinator is the person that makes the decisions, which is always really awkward. But I try not to meet with the children. And the reason why and different parent coordinators do different things, but the reason why I don't meet with children generally is because children need a safe place to talk to, a safe person and a safe space to speak with somebody. And I'm not necessarily that person because I'm not going to continue that relationship. And so I don't want to create a bond with the children, whether it's professional or not, and then just not be there in a year from now, or not be there in 2 years from now, or not be there in a month from now, depending on what happens.
Wouldn't it be important to understand what the kid's interest is, what the kid wants to do? Like, if the kid really wants to go back to school, shouldn't that be one of the deciding factors?
It's absolutely imperative. So what I do is I work with a play therapist, and I have the children.
A what therapist? A play therapist.
So play therapist is just the same as a therapist or a counselor, but they work with children, and they supply different mediums. So whether it's cards or whether it's Play-Doh or whether it's painting, because when kids are busy with their hands, they're not so much thinking about what they say, and they tend to be a lot more honest because they're not focused necessarily on saying the right thing or not upsetting someone. They're focused on the Play-Doh that they're playing with. And so they'll have more honest conversations. And it's just a type of therapy for younger kids. And so their voice absolutely should be heard. And the way I go about doing that is giving them a safe person that they can have throughout their lives, so that they always get to go back to the same person and have those conversations that are really difficult for kids that are in two-home families, because they try so hard to please both parents, and there's no safe place for them. And so a play therapist or a therapist will help me hear the kids' voices, but also make sure that the kids are in a safe place that they can share that information.
Fascinating. I never heard of a play therapist before. I actually just interviewed someone the other day that was a psychotherapist, registered psychotherapist, that was into something called EMDR, eye movement, something or other, resolution. And she said something similar. And all you had to do was sort of pat your chest, and you calmed down your anxiety, and you were able to realize your feelings and your thoughts and your beliefs far better than you would otherwise. I was a little bit surprised by that.
It's incredible.
I should try. I'm not sure. Okay, so we talked about school. One of the other big issues, I think has been whether you go back and forth between the homes during COVID-19. And I think a lot of parents have, I don't know this, but I hear rumors of this. A lot of parents have sort of used this as another fight that, you've got too many people in your house, and so therefore I'm not going to allow my kid to go to her father's house as often as they want, and sort of fighting custody through pandemic. Is that something that you're hearing about?
For sure. I think the pandemic has created some new battlegrounds and some new arenas for parents to battle. And I think in the beginning, certainly I saw in my practice that parents were using COVID-19 and the threat of COVID-19 to thwart access to the other parent. And then I believe it was towards the end of March, Justice Pazarak came out with a decision that said, absolutely not, this is not going to happen. Children need to be going back and forth. All court orders need to be honored, barring, of course, special circumstances. But for the most part, everything needs to be, the court orders need to be honored, and kids need to be seeing both their parents. From my perspective, and what I would say to my parents when they would come to me is, let's just take a second here and recognize that these kids, their entire world has just been turned upside down. They are not going to school. They can't see their friends. They can't go to the park. They can't play in the driveway. They can't do anything except be in the house while you're trying to work. And so there's probably some escalated conversations that are happening. How about we make sure that they have their two safe places and we keep those intact, meaning both their mom and their dad, or both parents. And educating parents and walking them through, it's fear that causes sometimes it's fear that causes these irrational decisions and these reactions to the pandemic and what they're going to do with their children. But I find if you just sit back for a second and listen to what the actual fear is and find out what's motivating the behavior, you can change it. So once that decision came down, there was a bunch of other decisions that came down that kind of echoed the same sentiment. And things started to calm down. And then we had back to school. And then things started to escalate again. But it's
okay, so we've got custody, back and forth from homes. We've got back to school. What are some other issues that you have to deal with today?
Some other issues were dad's bubble is too big, or mom's bubble is too big, or dad's having parties, or mom's having parties, and they're creating play dates. I know I also am a child protection mediator, and so there were also kids within the child protection system, meaning Children's Aid Society, that because all the supervision centers were shut down for COVID, parents weren't able to access their children if they had supervised access. through an agency. And so that created a huge issue. And the courts at the time were open for emergency motions and child protection motions, but really, really quite limited. And so it was really difficult for those parents and those children that had families in the child protection system to be able to access their children, which was another issue that was difficult to deal with. Children's Aid Society also received an influx of phone calls because parents were feeling like it was a child protection issue, that, you know, Jenny was allowed to play with Johnny next door and we were in a pandemic and one parent didn't agree with another parent's choice. But the court was very clear in that they weren't going to, unless in an emergency situation, they weren't going to battle back and forth whether Johnny gets to play with Jenny or Jenny gets to play with Johnny.
What about abuse issues? Are they more difficult to deal with, threatened abuse or claimed abuse during COVID-19?
So domestic violence during COVID-19 has certainly skyrocketed, and there's a number of reasons for that. And I think prior to COVID-19, we all had many different outlets, whether we would go to the gym, whether we would, we would be at work for 8 hours a day. We would then have a work dinner, we would have a golf function, or we would have all kinds of things that kept us out of maybe the family home. Another issue that happened was alternative partners, meaning affairs, is that people weren't able to access that as an outlet. And so when you can't access your outlets and you can't blow off that steam, whether it be golf, whatever it is, it's going to create an unfortunate situation within your home. And so perhaps some people that were never usually predisposed to domestic violence, there was arguments and everybody was already heightened. And then you had the pandemic and fear on top of it. So yeah, it was a recipe for domestic violence for sure. And then the difficulty is that it's very difficult to navigate your criminal law case and your family law case at the same time, because those two courts in Ontario don't speak to each other. And so it creates—
That's just a rule that they don't?
That's just a super good question. I don't have an answer to it, but they just don't speak to each other. So often what will happen in a criminal law case is that an order will be made by the criminal judge or imposed by the Crown, and the family law judge won't know about it, or vice versa, and they're competing. So you can't have direct or indirect contact with your former partner. Well, that makes it really difficult, because if you talk to your best friend to try and get access to your child, that's indirect contact. If you use emailing to speak with your ex to try and get access to your child, that's indirect contact. And so you have to make sure that if you've been unfortunate enough to experience domestic violence at any point, but certainly during COVID times, that your criminal law lawyer is speaking to your family law lawyer to ensure that both courts are kind of doing the same thing and everybody's on the same page. Because if not, you just get stuck in this rut of having to go back and forth between the courts and change orders, and that takes time. And time means you're not seeing your child in the meantime if you're the alleged abuser.
Right. Are people using threatened, like making up abuse as a way of threatening their spouse in this time period?
So I think that that's something that we see in family law, is that there are some people out there, and not everybody, and domestic violence is a really real thing, but there are some people out there that will use the knowledge of domestic violence and what it means for their to one up the other parent. Because usually if domestic violence situation happens, the offending parent is then removed from the house, and then they're also stopped from seeing the children. And that puts you in really good standing within the court situation, within the family courts, because you now are in the family home and the other person can't attend the family home, and you now have the children 100% of the time. And it's difficult for the alleged offender to have access to the children. And so there are some people absolutely out there that use that as a strategy in family law, because it's a strategy that works. The unfortunate part about that is it takes away from those victims that have actually experienced domestic violence. And it's really difficult for the courts to figure out who has experienced domestic violence and who hasn't experienced domestic violence. And unfortunately, for the alleged offender, their life, whether the domestic violence charge is real or not, their life and possibly any licenses that they hold or anything else like that is directly impacted, which means in a roundabout way that the kids are impacted, because if you have, I don't know, like an accountant or something, or a doctor who can't have a criminal charge on their record of abuse, if that charge is brought about and it's not accurate, it impacts the family because it impacts their ability to work and financially provide for the family. So it's a vicious cycle. But domestic violence is real. It's real in COVID, and people have been affected by it. And there are, it sounds really quite flippant to say a few bad apples spoil the bunch, but there are people out there that use domestic violence and separation and divorce as a way to get ahead in family courts, and it's not right.
Michelle Walton, a parental coordinator, a mediator, and an arbitrator, thank you so much for joining us tonight. Really appreciate it. If people want to contact you because they need your services, how do they do that?
You can reach me at michelle@phoenixfdr.ca.
Thank you so much for joining us. I really appreciate it.
Thank you.
Well, that's an interesting conversation. We're going to take a break and come back with another lawyer, a litigation lawyer, to find out some other issues during COVID-19, particularly as it relates to employment. Stay with us. Well, welcome back to the Brian Crombie Radio Hour. That was a fascinating conversation we had just had about some issues in regards to children during COVID-19. We've now been joined by Barbara Green. She's an employment lawyer at the law firm of Robbins Appleby LLP in Toronto. She represents both employees and employers in employment and human rights related matters. And we're going to chat about some of those issues in regards to non-unionized employees in regards to the time of the strange time of COVID-19 that we're going through right now. So Barbara, thank you so much for joining us. How are you tonight?
I'm doing great. Thank you so much for having me tonight.
It's my pleasure. So tell me, how long have you been practicing employment law, if you could?
So I've been practicing for about 10 years, and I am happy that I get to represent the interests of both employees and employers, because you get to see the flip side of most situations. So you can put yourself in the situation of an employee when you're dealing with an employer, and vice versa.
I can imagine that gets fun and challenging at times. And I've gone through a bunch of your practice areas in the past, and some of the cases that you've done. You've actually represented some interesting people, both from a company standpoint as well as from a personal standpoint. And I might chat with you later on in the interview if we have time about some of them. One of the most interesting one was the proper attire for waitresses.
Yeah, that's the human rights case with respect to the beer market. So that was really interesting. In fact, the Human Rights Commission took notice of this case and ended up changing their laws accordingly. So what's really interesting is that people can have a real influence on the law without even knowing it. So my client didn't intend to change the law. She was just very, well, of course, and she was just very upset at having her working conditions changed and being forced to wear what she considered to be inappropriate attire in the workplace. She felt that it was discriminatory, and it turns out she was correct.
So while we're talking about it, let's give a little bit of information. This was a waitress at a beer market who said that she was asked to wear skimpy clothes, and the male waiters were wearing khakis and button-down shirts. And so it was completely inappropriate that the females had completely different attire than the males. Is that a fair summary?
That's an excellent summary. And I think the difficult part for her is that prior to this, both the female and male servers had a similar attire. So everything had stayed the same for the men, and yet for the women, they were expected to wear sexy and revealing outfits, again, presumably to draw in customers. And again, she felt this was discriminatory and degrading, and she challenged this. And Cara Foods backed down and changed its position and changed the dress code for the female servers, and to make them to be similar to that of the male servers.
So I guess it would have been okay if the men were asked to wear skimpy clothes too.
Well, I don't know if I would have had a problem with that, but maybe not. But again, it's really an important issue. I mean, it is truly important, because it's important to feel safe in the workplace. It's important to feel that you're treated in a proper and fair manner. And we spend so much time in work, and we want to be treated fairly. We do not want to suffer discrimination. We do not want to suffer harassment. We want to be treated as equal to our male counterparts. It's really important. So it was a really important issue, and it's really a brave issue to take on. Because, you know, she was a young woman, many women wouldn't have felt so confident to take on care of foods with what many consider to be a trivial matter, and it gained national attention.
Well, and congratulations to both her and for you in taking the case on and winning. And as you said, changing the law.
It's exciting. It's exciting what one person can do when they try to make a difference, even if it's just, again, for themselves.
Well, I couldn't agree more. So let's talk about COVID-19 and some of the issues that you're dealing with right now. You know, lots of employees are being recalled after furloughs or layoffs and things like that. What, if any, are the rights employees have to say no?
Right. This is a hot topic because a lot of people have been laid off. There was legislation that arguably permitted temporary layoffs, whereas there weren't rights to do so before. So you have many employees who are now faced with a position of they're being asked to come back, and what should they do when there are certain circumstances which, from their perspective, prevent them from coming back. So one of the most important ones are health and safety considerations, because the employer has an obligation to provide a safe working environment for employees. So certainly if an employee feels that they're being asked to work in unsafe or hazardous conditions, they're entitled to refuse to come back to work. And normally what will adjust or what will solve that problem is having an occupational health and safety inspector come in, have a look at the workplace, see if it's in fact safe, because somebody may feel subjectively that the workplace is unsafe. And truly the inspector, who has a lot of experience, looks at this and says, you know, this all looks fine to me. There's certainly sufficient COVID-19 protections in this workplace, and there shouldn't be an issue with employees working here. So that's one way of resolving the problem, having somebody neutral come in who's experienced and make that determination.
Now, I know you don't want to talk about unionized people, and so maybe we can address this, but I've heard a lot of teachers that are really worried about going back to school. So, you know, if you're worried about COVID-19, if you're worried, you know, that having to go back to your job means that you're going to be exposed to COVID-19, do you have the right to say no?
Okay, so let's talk for a minute about subjective fears versus objective fears. So many of us in general are fearful of COVID-19. I certainly have my own concerns. I'm concerned for my children in going back to school. So I get it from a human perspective, from a subjective perspective, but employers do not have an obligation to accommodate for subjective fears. Now, if somebody has truly an anxious disorder, they truly are diagnosed with an anxious condition, an illness, a disease, well, of course, then the employer may have an obligation to accommodate for that. So yes, I certainly appreciate that we all have fears. It's a scary time. We don't know what's going on. Some of us have to take public transportation. We're scared about that. But again, employers have certain duties to accommodate, and some fears do not have to be accommodated.
What if I've got a guy in the cubicle next to me that's coughing all the time?
Well, I think that's something you should raise with the employer, and the employer should have proper protocols in place to deal with this. So this should be brought to the employer's attention so that it can take active steps to protect the employees in the workplace, because an employer has an obligation to protect other employees in the workplace. So that may require, first of all, employers should have workplace policies to address COVID-19, right? What are the circumstances? First of all, people should be self-monitoring for their own symptoms and required to stay home and required to depart if they're exhibiting any symptoms. So this is something important for employers to have, is to have a proper protocol for what do we do. And employees should know that they should report this to HR. They should report this to an office manager, whoever it should be reported to, so that steps can be immediately taken to protect everybody in the workplace.
Okay, if the person has a cough and they're not smart enough themselves to stay home, and I complain to HR and HR does nothing about it, do I have the right to leave because I'm feeling unsafe?
Yeah, absolutely. I mean, everybody has a right to have a safe workplace environment. And I think that's an objective fear. Now, again, does it cross into subjective? So every person with a cough, but I think for me, objectively, if somebody's coughing and I'm not sure what's going on and I feel that I'm in an unsafe environment, yes, I would go home. The other thing too is it's about being practical. So, I mean, I don't think it's going to be a problem to go home for the day if you feel unsafe. Right now, if you decide to stay home for 3 weeks, that may be a different situation. So one of the things I tell employers and employees, keep an open dialogue. So an employee shouldn't just get up and leave for the day. That's completely inappropriate, right? There has to be open communication about, are you having a subjective fear, or do you have a reasonable workplace safety concern that must be addressed?
Okay. So workplace safety. Let's take it maybe to an extreme. But you know what? I think most Canadians are being very accommodative and adhering to physical distancing, social distancing guidelines, and wearing of masks. But some are not. And actually, I'm surprised at how many people on social media lately are commenting that they're an anti-masker and that you know, for whatever reason. What if my coworker isn't adhering to wearing a mask?
Well, again, employers really should have proper workplace protocols in place, proper handbooks, proper guidelines to deal with what will happen in our workplace with respect to COVID-19 protections. So if an employee refuses to comply with those workplace policies, that employee can be asked to leave and should be asked to leave, because it's not about you as a subjective individual with saying, you know, I don't want to wear a mask because I feel this violates my rights. It's not about you. It's about everybody else in the workplace. It's about creating, and I keep saying this, creating a safe workplace environment. So again, you can have all the feelings you have about this particular issue, but it's up to the employer to create a safe workplace environment. And if somebody says, I just refuse to wear a mask, well, you know what, then stay home.
Lots of people have been laid off and or furloughed, or whatever you want to call it. Let's say they come back and they're terminated. What are their rights?
Well, as in every situation with respect to a termination, I'm assuming a person who's terminated without cause will be given a termination package, right? So you are entitled to receive a package, and you're entitled to receive, again, depending on what your employment contract says, you're entitled to receive notice or pay in lieu of notice. You may be entitled to severance pay, and you may be entitled to common law notice. And that really depends on what you agree to at the outset of your employment in terms of your employment contract. But again, if you are packaged out, it's very important to seek legal advice to determine through a legal help what your legal rights are and what your remedies are.
And what is the compensation? Is it like a week, a month, a year, or a week, a month, or something like that?
Okay, so I'll break it down into a few categories, because this is an area which is really difficult. And this is where people should not engage in the self-help of Google. I think it's really bad. The same way as I don't go Googling my medical symptoms to figure out what I have. Do not Google to figure out what your legal entitlements are. We go to law school for a reason. It's complicated. So we have statutory entitlements. So under the Employment Standards Act, we have termination. We have, termination pay, or we get notice of termination. So we get 1 week per year of service up to 8 weeks. Now, in addition, if
1 week of service,
one week per year of service up to a maximum of 8 weeks.
Okay.
That's notice or pay in lieu. So an employer can give working notice, or they can give pay in lieu of that working notice. So that's the category of termination pay. So in addition, some employers are required to pay what's called severance pay. So severance pay is an entirely different category of compensation, and it's an additional 1 week per year of service up to 26 weeks. So it maxes out at 26 weeks. And this is only for employees who've been employed for 5 years or more, where the employer has the payroll of $2.5 million. So this tends to be for larger employers where there's the obligation to pay severance pay, or there's been a severance of 50 or more employees in a 6-month period. So that's a completely different category. Now here's the big one, the one that people don't quite understand. And these are the common law entitlements. So you have to look to your employment contract, because some employment contracts negate or get rid of your common law entitlements. But the common law is a different way of looking at something. This is judge-made law. And judges will take into account certain factors to decide what would it take for someone in this employee's circumstances to find comparable alternative employment. So the factors that are important is age. So an employee who's over 40 years old, which would include me, sadly, are considered more difficult to reemploy. So as you near towards the age of what would have been formerly the age of retirement, you would be entitled to a lengthier notice period. Those with supervisory or managerial duties, well, they are too entitled to lengthier notice period. Your length of service, also a very important consideration. So those who have worked for longer periods of time are presumably entitled to lengthier notice periods. Inducement is a factor. So let's say you had a secure job and you were actively poached to leave that secure job and you took a new job only to be terminated shortly thereafter. Well, inducement is a factor as well. So the courts take all these factors, kind of jumble them up together and come up with no formula, but sort of a field test as to how those factors balance in terms of your entitlements. So you could be employed for, let's say, 2 years, and if you're in a senior position and you might be an older employee, you could be entitled to 6 months. So it's not a direct correlation only in terms of length of service, but all of those factors. So when individuals say to me, well, I know what I'm worth and I think my severance package is pretty good. Well, judges know if your package is pretty good, and lawyers sort of have this field test based on what prior judges have decided someone is worth.
So in other words, give Barbara Green a call.
Listen, absolutely. I'm here. Get proper. I mean, my guidance is always get proper legal advice. This is really important. I mean, a time when you're terminated, it's a very emotional time, right? Some people are happy. Some people are like, thank goodness I got packaged out. But for a lot of people, it's a difficult time. And on top of it, you're dealing with COVID-19. So
Barbara, what is constructive dismissal?
Okay. Constructive dismissal, also a complicated topic that's people don't quite understand. So a constructive dismissal is when there's been a fundamental change in the employment relationship, which makes it basically impossible to continue the working relationship. And in that situation, the person is basically resigning, so they can't continue to work in their situation. Now, again, there's a caveat to that, but typically don't continue to work under those working conditions. And instead they say, well, I should be packaged out as though I was terminated on a without cause basis. So essentially, I'll give you an example. If I feel that I've been constantly harassed and bullied in the workplace, and this is a completely toxic work environment for me, and I cannot continue to come in even another single day, then I'm going to not resign, but I will say I'm no longer coming to work. I have been constructively dismissed. I am entitled to my damages. Now, it's a complicated topic because it's a very high threshold to meet that threshold of constructive dismissal. So it's very risky to resign without having clear situation. And again, there's never a clear-cut situation of constructive dismissal. Some more obvious examples are situations where your compensation has been drastically reduced. That's a more obvious one. So right. You don't have to stay on under working conditions that you didn't sign up for to begin with. That's just not fair. So that may be a more obvious case of constructive dismissal.
We're chatting with Barbara Green tonight, an employment litigation lawyer, about some employment concerns, both in COVID-19 as well as just in regular everyday employment law. We're going to take a break for some messages and come back in just a minute. Stay with us. Well, welcome back to the Brian Crombie Radio Hour on Saga 960. We're chatting with Barbara Green, who is a lawyer with an employment lawyer at the law firm of Robbins Appleby LLP in Toronto, and she represents both employers as well as employees in employment and human rights related matters. When we end up, we'll ask her to give us her coordinates so that if any of you need her assistance, you'll be able to contact her. We've been talking about COVID-19 and some issues in regards to it. But maybe, Barbara, we could sort of, just broaden the conversation for the last couple of minutes here. And talk about some other issues that have really been in the news and you've undoubtedly dealt with. Have you dealt with bullies or toxic people in the workplace? And what are your thoughts on that?
Hot topic and really unfortunate situation. So for employers, I'm going to say this, get rid of them. They become more toxic. They become more difficult. You will expose yourself to claims. You are going to have other employees who will bring claims against you. The difficulty is employers become fearful of them. So again, I say to employers, get rid of them quickly. There's a cost involved. You may have to package them out. And the other option with them is keep documents. Give them written warnings. Give them verbal warnings. Document. And if you document sufficiently, maybe you can get rid of them for cause. But if you've got to pay them out and get rid of them. COVID-19 is so difficult already. It's such a difficult world. Nobody wants to come into a toxic workplace environment.
Where's the line between toxic and just people that are uncouth, that may swear a lot and stuff like that? Is that appropriate, or no, you can't swear?
Okay, I will tell you this. I have seen workplace investigations over things that I consider to be absolutely ridiculous. So nowadays, you can be investigated for anything, harsh emails, where you may be a bit condescending. So it's hard to draw the line between what an employer will actually say, this warrants an investigation, and we're going to investigate this employee's conduct. So it's really like everything's up for grabs. So be careful, be cautious. You will be investigated. You have to be mindful. And a lot of people are well, they mean well. They just don't mean it. It's unintentional. But still, we have to be really cautious. We're in a different world now. We have to be really careful what we say to each other.
What about sexual harassment? Have you dealt with a sexual harassment case? What are your comments there?
Yeah, it's very sad. And in my experience, and it's a really, when there's, ill intention, obviously that's really tragic. But in my experience, we also come across individuals who've been raised in a different environment. We have men who've been raised in an environment where they think it's okay to say certain things to women. Like they just really don't know any better, and they're being terminated. They're being terminated for cause for this conduct. So we can't accept what we once accepted is no longer acceptable. So I've seen a lot of terminations for cause for reasons that maybe a while ago would have been considered, the conduct would have been considered okay, acceptable, even expected. And that's not what we're seeing now.
Okay, so I had a lawyer once tell me, do not have a meeting with a female employee behind a closed door. Keep the door open.
Yeah, it's all about being careful. It's all about being mindful. It's about being cautious. Don't create a situation where, you put yourself into potential jeopardy. So yeah, be mindful, have two people in meetings, right? Have, a witness. You never want to be like, he versus she. You have to be mindful of these things. Listen, it can always be over the top, right? But it's important to be mindful. It's important to protect oneself, do the right thing. And again, it sometimes borders on ridiculous. And I get it from a practical perspective. Some of this is, as I see, emails that have a harsh tone, people complain about them. It borders on ridiculous, but that's the world we're living in. It is what it is.
Can a male superior compliment a female subordinate today?
It's risky. I mean, again, it goes back to, intentions don't matter, right? So I think it's perfectly acceptable sometimes, like it depends on what you say. And I think why say it at all, right? Like we're living in a world where we are criticized for the words we used. We don't know what the underlying intention is. I would caution employees and employers, stay away from it. Like,
what if you wanted to ask a coworker out for a date?
That's, first of all, you have to be mindful of what the workplace policies are about that sort of behavior to begin with. But again, it's risky to begin with because, you never know where things go. Is one person going to want to resign from their job if it gets messy? So, I can't stop people from living their life. It's all about making good decisions. And if you really feel that this person's worth it, then you go for it, right? It's about like being practical. There's not always a legal answer. There's also about being practical. Like, can you live without this person because you don't want to make your workplace messy? Yeah, maybe you will.
If you were of the belief that you had been sexually harassed, what should you do?
Go to HR, First of all, document the situation and go to HR. If you don't have an HR department, go to your office manager, go to the employer directly, make sure this is documented and deal with it right away. Like it's a heavy burden. I mean, I'm making light of it to some degree, and it's a very, very serious issue. It's one that's close to my heart. I work in a male-dominated environment. I know what it's like to be, one of the few women who's a partner in a law firm. And I think the guys I work with are fantastic. I'm very lucky, right? So if you feel victimized and you feel bullied and you feel targeted, speak with someone immediately. Get the help you need.
If
right?
your male partners all go out for drinks, will you join them? Do you feel comfortable joining them, or will you say no?
Absolutely. They're a great bunch of guys. They're great. And I have also female partners now too, and they're great too.
Okay. Race relations have become a big issue in the last couple of months for all the obvious reasons of what happened in Minneapolis, et cetera. What if you think you're subject to racism?
It's difficult. I mean, clearly you have human rights protections, right? Now, this is where it becomes legal and practical. So you've got your legal protections and you've got your practical problem. So if you're going to raise an issue in the workplace, are you going to be comfortable still working there? Do you want to still work there? Should you bring a human rights complaint? What are your other options, right? So, I mean, again, human rights, always, the tribunal's always available to you to file a complaint. And you have to look at yourself and say, you know, what's another practical outcome? Maybe I need to leave this job. Right? So do I pursue a human rights claim and leave my job and find something where I think I'm a better fit? Can human resources deal with this? You know, or is this really just a subjective feeling I have? But those subjective feelings are real and I don't want to minimize them. Like I really take, when people come to me and say, I have a situation, their subjective feelings matter. Feelings matter. Your perspective matters. It's real for you.
Well, Barbara Green, employment litigation lawyer with Robbins Appleby LLP. Thank you for joining us tonight and talking about some of these issues. I think there is going to be a lot of people that are going to be needing your and people like your services, because there's been a lot of layoffs, there's been a lot of bankruptcies, there's been a lot of furloughs, there's been a lot of people that have been going through some challenging times, and they're going to have to try to figure out what the right thing is for them to do. And I worry that a lot of people don't know their rights. And you know, I think that we're going to have higher unemployment, which means that sort of there's more power in the employer's situation, and people have to stand up for themselves. And so hopefully with your help, they'll be able to stand up for themselves. So thank you very much for your words of wisdom on our show. If people want to contact you and get your services, how do they do that?
Well, my phone number is 416-360-3379, and my email is bgreen@robapp.com. And the fastest thing to do is just Google me. You can find me. It's Barbara Green.
Barbara Green, thank you so much for joining us tonight. I really appreciate it. Well, that's the Brian Crombie Radio Hour for tonight. Two different legal-oriented people talking about issues during COVID-19. The first one talking about a whole bunch of parental issues, and the second one talking about a bunch of employment issues. And if I could just leave you with a few words, is to the extent that you can solve these problems without getting into the legal process, particularly the court process, you're far better off. So understand your rights, get the right advice, but if you can settle it at a court, settle it at a court. Thanks for joining us tonight.